Hello and welcome to Commonwealth Politics. I'm Mike Krasanik.
And I'm Mark Kemper.
Today we're going to talk about public records and public records reform. One of the issues that has come forward in recent months and weeks is the need for some kind of change in the ability of citizens and groups to have access to public records. And there has been some criticism in Massachusetts about the lack of openness, or often called transparency, with regard to public records. So to sift all this through, we have two very, very distinguished people here on our panel today. Senator Jason Lewis, a Democrat from Winchester who is involved in the legislative issue, and also Pam Wilmot, who is from Common Cause and citizen advocacy group that's quite interested in the issue of public records. So for our first question, we'll go to Mark Kemper.
So, Senator Lewis, I'd like to start with you. Could you talk a little bit broadly here about some of the issues that the legislature is considering? Mike noted that there's been some concern raised about the inadequate nature of the public records law at this point in Massachusetts. What are some of those concerns, and where's the legislature at in addressing those?
Thank you for inviting me to be on the show, and thank you for covering what I think is a really important topic, because as you mentioned in the outset, this is really about transparency and government being accountable to our citizens, because if our citizens have trouble accessing government records that rightly belong in the public domain, then our democracy isn't working the way it should. So that's why this is a very important issue. In Massachusetts, our public records law, which is Chapter 66, dates all the way back to 1973. And it really hasn't been updated since then, and an update is long overdue. So that's why this issue has gained momentum, and why the legislature is now actively considering an update to the public records law. And what we're trying to do is several things. We're trying to make sure that information is available online wherever possible, because of course in 1973 we didn't even have computers, never mind the internet. So we want to make sure information is online, and wherever possible it's provided in electronic format and citizens can search that information. So make it easy for them and convenient. Second, we want to ensure that each state agency and city and town designates a person who can be the point of contact for public records requests when they come in, so that we can streamline the requests. And then third, we want to make sure that the fees that are charged by state agencies and by cities and towns, to reimburse actual expenses incurred in complying with the records requests, are not excessive, because we have seen problems with fees that have been really excessive that have been charged, and that can act as a deterrent to public records requests. And then lastly, we want to make sure that there's some teeth in the law, and that state agencies and cities and towns really do comply with the law. And most of them do today, but there have been, unfortunately, examples where they haven't been complying. So we want to also ensure that when a public records request is not honored, and it should have been, that the party that requested the information can go to court and can actually get attorney's fees awarded if they are successful. And that's something that most other states do.
Pam, would you like to elaborate a little bit on some of the concerns that Common Cause has with respect to open government and public records in Massachusetts?
Yeah, I think I'll back up just a little bit and talk about how we stack up in Massachusetts vis-a-vis other states in the country. Massachusetts is the cradle of liberty, but when it comes to information, our public records law, as Senator said, hasn't been updated in 30 years, and it also, actually 40 years, and it also substantially worse than other places. We consistently are rated at the bottom, if not number 50 out of 50 states, in the bottom 10. That's just not someplace we should be. This year we also won something called the Golden Padlock Award, which is for the most secretive agency in the nation, and that was for our state police. And they beat out the Texas Police Department and the Federal Department of Defense. Now that's a pretty ignominious honor that our state received, and certainly not where we want to be. I've been in this business a long time, and I have seen escalating stories of unresponsive agencies and municipalities, fees being used to deter requesters, everything from $40,000 for a spreadsheet of previous Freedom Information requests to $6,000 for the computer privacy use policy in a school system. Just the list goes on and on. And I got interviewed by one media reporter because a family couldn't get the name of the snowplow that hit their car because it was being withheld. These are the kinds of things that shouldn't be happening, and they're happening all too frequently. So, as Senator Lewis said, there's really a lot of different things that need to change to update the law in order to accommodate these things. And for us, and we're working very closely with the ACLU of Massachusetts and a number of organizations. We actually have 40 in our coalition. But the top 3 are really around providing cost controls, ensuring that those excessive costs don't get charged. As Senator Lewis said, putting teeth in the law, making sure that enforcement mechanisms are there. We're only one of 3 states that does not provide the opportunity for attorney's fees for successful litigants. So if you have to go to court, and God forbid nobody really wants to go to court, you have to foot the whole bill, and there's no possibility even for the court to award those. Now, the House and Senate have both approved bills that change all of these things. I think there's strengths and there's weaknesses. The Senate bill is a stronger bill, but there's things we like about in different provisions. The third, I would say, is the timelines. So ensuring that public records are turned over in a timely manner. And the House and the Senate have very different takes on that. So we've been pushing for, the records access officer is very important, online is very important, but really making sure that where the rubber hits the road with time, cost, and enforcement, that those provisions are as strong as they can be.
Well, let's just talk a little bit about the time issue. What are the differences right now between the House and Senate versions of the legislation in terms of the time issue?
Pretty substantial. The House version has municipalities being required to turn over records within 76 days for a municipality or 60 for a state agency. That's a long time. The Senate version is 30 days, and that's much more reasonable, is much more in concert with what other states do. I should point out that the current law actually says they have to comply in 10 days. That doesn't actually been interpreted to mean they have to produce the documents in 10 days, but that's what the law says. So the Senate version is much more in tune with what's happening across the country. 76 days is just out of really the question. There's also the possibility of asking for more time in both of those bills from the Secretary of State's office that has a supervisor of public records. And the Senate caps that at 30, and then the House would leave that unlimited, and that's too much.
Senator Lewis, where does Governor Baker fall in this whole issue of public records? Is he on the Senate side, the House side, or does he have a different view?
Well, I think to the governor's credit, when he came into office, he recognized some of these issues in terms of compliance with the law and making sure that information that belongs in the public domain is available to citizens. So he actually issued an executive order earlier last year that does implement some of these reforms that we are looking to do through the legislation in terms of capping some of the fees that can be charged, and also around the time that what Pam was just talking about, the time that an agency can take to respond. Now, his executive order applies just to state agencies, not to cities and towns. This legislation, hopefully when it's successful and reaches his desk, would apply to all public agencies in the Commonwealth. But I think the governor hasn't said specifically, weighed in on specific provisions, because he usually doesn't like to do that. But once as Pam said, the Senate and the House have both passed bills that have many areas of commonality, but some areas of difference, and we are now in a conference committee that is charged with reconciling those differences into one bill. Hopefully that will then pass the House and Senate and will reach the governor's desk.
So will we see something in front of the governor in 2016?
I'm very hopeful we will. I know there's a lot of people working hard in the legislature, both the House and the Senate, to make that happen. And I would say overall, I'm fairly confident that we will get a final bill on the governor's desk, and I would expect that he would sign it.
Yeah, I would say I'd be shocked if a bill doesn't get there. You know, how strong it is still a question. You know, is it going to be really moving Massachusetts up to, you know, above the middle of the pack, or are we going to go from the bottom to the middle? And that's really kind of the question. Is
there any debate right now over what kinds of records should be available? I mean, you mentioned the state police, and I don't know whether we're talking about concerns about, are we talking disciplinary, you know, police that have engaged in some type of corruption or have been disciplined, and whether it's access to those kinds of records, or what kinds of things would Common Cause like to see access to that currently isn't available, or is that even really not an issue at this point?
This bill actually doesn't deal with that question, although there are really substantial questions that need to be dealt with in that area, particularly in the area of police activity. Because since the public records law has passed, there have been a number of other laws, including the Corey law about criminal information records, and the intersection between those in some unforeseeable ways has started to foreclose, which even used to be public information. So that's really important, I think, for us to take a look at. And the House passed as part of their bill, sort of a study to look at some of those issues. And we think that's a good idea. Both the application potentially to more agencies and then some of the exemptions within them. We have 26 exemptions to the public records law. So things like criminal investigations or policy in development or a privacy exemption. Those exemptions, some of which are broader or narrower, are actually optional exemptions. They mean that you can, as an agency, turn over that information, but you can also withhold it. And so, you know, one thing is, I think, more attention to these issues, so there's more education available, and that's a piece that we, you know, I think is important, because there is a lot of misunderstanding of the law as well. And having the records access officer, he'll have, or she'll have access to that information.
I guess maybe this is a naive question, but you mentioned the people who wanted to find out who hit their car with the snowplow. Yeah. How did we get to that, where someone gets hit by a snowplow and goes to the police and say, please give me the name of who hit our car? It seems to me a very simple question that should have no problem in terms of resolving it as far as divulging the name. Am I missing something here? Or
no, and I think the name did eventually get turned over after it appeared on the news, but and it wasn't the police, it was a city agency, some lawyer. There is an exemption for a litigation strategy, and that was their excuse for not providing information. That's not what that exemption means. And if they had gone to court, they would have lost very quickly. And that's why it's important to have, you know, your costs covered if you successfully litigate this, because otherwise, you know, there's no reason. On the one side, maybe the city's looking at, well, if we turn over the information, then maybe they'll be more likely to sue because they know who to sue rather than just us. And then there's nothing on the other side. So it's not the right thing to do, obviously, and ultimately.
Do we have too many exemptions? Maybe is that part of the issue, or?
The exemptions, I think there are some that are broad that need to be looked at around the privacy exemption. I think the way it was initially written was intended to be more narrowly construed than it has been. And some of them, just like a law, they're interpreted along the way. The Secretary of State has a fair amount of latitude. So, for example, there was just one instance where there's ongoing criminal investigations aren't included. And that makes sense because you don't want to prejudice an investigation by making information public. The Globe asked about I think it was the Globe, asked some questions about a case that was 60 years old. And the 50 years old. And the secretary, they wouldn't turn over the information. And the secretary upheld the ruling of the municipality that it wasn't, that it was still private. And then there was too much brouhaha, and he ended up changing his mind and getting the information.
If I could just add a thought on that, it does get fairly challenging because from two respects. One is, as Pam has been identifying, there's a spectrum here and kind of a balancing act between information that does rightly belong in the public domain and information there is a valid reason to keep that information confidential, maybe not forever, but for some period of time, and there's a good reason for that. And that's why these exemptions were initially written into the law, but it does raise valid questions as things change over time. Should it still be an exemption? Should it be narrower? And there are tricky issues there to work through. The other challenge is that the interpretation of this can differ across different cities and towns, across different state agencies. They may interpret it differently. We do have the supervisor of records who sits in the Secretary of State's office, who has a role in terms of an appeals process and making decisions to try to have consistent interpretation and enforcement. But that's it has been a challenge we've seen where, one public entity might interpret it differently than another.
Well, I know one of the I guess the distinctions about the committee that's considering this, at least within the Senate, I don't know about the House, but that it was an open committee process, right? The committee that was discussing the reforms was open and it wasn't closed. You mentioned policy development exception. Can a committee like a Senate committee or some other town board or council, can they go into executive session and talk about policy and essentially then make up their minds in that context, and then that's not then available?
Well,
should that be the case, or
there's
what's the
sort
rule
of
on
two
that?
different things here you're also getting into. One is the access to records, right, public records, which was this. There's also our open meeting law,
Right.
which is another body of law which relates to it. It's a similar issue, which is
Right.
transparency. We're trying to make sure that when public bodies are meeting and discussing issues of public concern, that the public has insight into that. And that's an important law too, and that has been received some updates over the years, and there's some questions today about whether we need to make changes there. But the open meeting law does have exceptions also, where if it's, like, for example, if a city council is discussing labor negotiations or personnel issues, that they can go into executive session and that. So it's not exactly the same as the public records, but it's kind of a related issue.
And the other thing is, this committee is a joint, and neither of these laws apply to the legislature. I mean, they have rules that require certain things to be open and then allow other things to go into executive session. So conference committees, and this is a joint House and Senate, for example, do often or most often vote to go into executive session. There was a period in Massachusetts where that was not an option for these committees, and they had to be conducted in public. But that was a while ago. But for us, I think what is the biggest problem, and these are all issues. Don't get me wrong. The biggest issue is that the law that we have that guarantees public records, even when there's no ambiguity regardless whether it's public or not, isn't always being followed, and too often is not. And so we need to, put those procedures in place to fix that, and that's what this legislation is primarily about.
Right. Senator, if this legislation passes, which I'm sure it will in some form, through the conference committee and goes to the governor, Pam has said we're number 50 in, how does this, where do we go? Do we go to number 25 on this, or number 10, or we go right to the top with this?
We don't like being at the bottom of the pack. We like to pride ourselves in Massachusetts in being a leader on many issues. We're a leader when it comes to the performance of our schools. We're a leader when it comes to universal health care access. We're a leader in civil rights, first state to have same-sex marriage and other. So we should aspire to be leaders. I would hope that with the passage of this legislation, we will really modernize the public records law, and we will be right up there among the states in terms of having a very strong law and guaranteeing access to the public to their information. Hard to say exactly where we'll end up because, again, it is a negotiation between the House and the Senate, and there are valid viewpoints that do express some concerns about some of these provisions. For example, the Massachusetts Municipal Association, which represents all of our 351 cities and towns, has expressed some concerns about particularly small towns which have very small budgets and sometimes don't even have a full-time town clerk who's probably going to be the public records officer. Maybe they only work 2 or 3 days a week. So if you have too tight a time frame to respond, or if you're too strict in sort of reimbursement of fees, that they worry that the community could incur expenses in complying with a request that they don't get reimbursed, and they have very tight budgets to begin with. So, those are valid concerns that as policymakers we do have to weigh that, and we have to weigh that against the public interest in getting the information and try to seek the right balance.
Well, how are fees established under the current law, and what's the discussion on how that might change under the
Well,
model?
the current law is allowed to make a reasonable charge for actual cost. The problem is that, what is reasonable and what is actual. So it is currently okay to charge a requester $300 an hour to have a Boston attorney or more review to see whether the exemption does apply or not. So your determination of whether it's public or not, the requester can have to be forced to pay for that. And that's not right. And most states, it's about at the 50% line, prohibit that kind of charge, or for withholding information from an otherwise public document. So, we want to take out this information that might be private, or, we'll give you this policy document, but we want to take out this section that isn't really clear yet where we're going to come out. So those are some questions. With the Senate bill and the House bill both, and the governor both have a $25 an hour cap, but they apply it differently. The governor and the House only apply it to agencies. The Senate applies it across the board. We agree with the Senate. We'd like to see that $25 an hour cap apply across the board. And of course, if it's less than that, you'd also pay less. But paying high-priced lawyers to determine that you can't have a record or you can't have a portion of a record just seems like an unfair burden on the requester. I think there is sort of a worldview almost question in some places of, is this a core government function that government should pay for, providing public documents and all the infrastructure and costs that are required? Or is it something that whoever wants information should pay everything related to that? And we've been sort of in that second model, and most states are more in the first model. And it's a big jump between those ways of looking at things.
Well, I'll ask you the same question I asked the senator. As you see this bill unfolding, is this a small step forward? Is this a modest reform? Is this a major revolution in public records? How do you see this unfolding? And what will you be saying once the governor puts his
Well, I
John
don't know.
Hancock on the
I don't
bill?
know what it's going to say, so I can't commit to where we'll be going. But, I think that this is a substantial issue. The Senate bill particularly was a substantial and important reform. Are we going to be number one? No. I mean, we're not there. But we've had so far to go, and we've seen a progression in other states. Nobody started from where we were and ended up number one. They kind of started to update their law and then moved.
What's the gold? Who's got the gold standard here in terms of number one? Is there who should Massachusetts look to?
There's a number of states, and just like any comparison, there's something that's good here and better
I see.
there.
Okay.
So
In certain areas, some states are stronger than others.
Okay.
yeah, but in New England, Vermont is generally pretty good. Florida has been a model in many instances. Washington State. There's a lot of different ones. And these interstate comparisons are always tricky.
And we are, both when we debated the bill in the Senate and now in the conference committee, we are certainly looking at other states to sort of see what are the best practices, and we want to see what are the best practices in terms of the time frame to respond, what are the best practices in terms of putting reasonable restrictions on expenses and then on enforcement. So hopefully the final legislation that we come to craft will reflect that kind of best practices in different areas of the public records law.
We just got a couple minutes, Mark, if you want to
I mean,
throw the last question out
just
here.
the last question. I mean, I know the media clearly is deeply interested in this question. I mean, we read about this in the Globe and the television stations are talking about it. Is there anybody else that you're encountering that really does care about? I mean, we know Common Cause does, but who are some of the other players involved in the policymaking process that are deeply interested in this issue?
I think this is important to average citizens. They sometimes aren't thinking about it until there is public information that they then realize that that's important to their themselves, their family, an organization, a community group that they're part of. Right now the main stakeholders at the table are Common Cause and the ACLU and the Newspaper Publishers Association certainly, and then the Mass Municipal Association sort of with another somewhat different perspective. But I think this is important to every citizen.
That's sort of our lead organizations, along with the League of Women Voters and the New England Freedom of Information Coalition, which is also another sort of news media citizen conglomeration. But also environmental organizations. There's a lot of environmental organizations that have been seeking public information around pollution and not being able to receive them. There have been some other civil rights and citizens groups that are trying to get information on their issues and having trouble. So as I said, there are 40 different organizations, and they really span a huge wide range of interests.
And I just want to say this coalition and Common Cause has been a real leader in it, have done tremendous work in raising the profile of the issue and helping to educate policymakers and in general helping to move us forward.
Yeah. Well, Senator Jason Lewis and Pam Wilmot, we want to thank you very much for helping us better understand an important issue here, the public records issues. Thank you for your presence here today.
Thanks for tuning in to Commonwealth Politics. We'll see you next time.
Leadership development, professional goal attainment, personal satisfaction. If you're employed in the public or nonprofit sectors and are aspiring to the next level of performance, the nationally accredited Master of Public Administration program at Bridgewater State University will get you there. Visit the university's website for more information.